In the previous section, we discussed the essential elements that make a deed valid under Arizona law. Competent parties, granting language, a sufficient property description, consideration, delivery, acceptance, acknowledgement, and recording. While recording is not required for a deed to be valid between the grantor and the grantee, it plays a crucial role in protecting ownership rights against the claims of third parties. This section explores the legal, financial, and practical implications of recording or failing to record a deed in Arizona real estate transactions and ties this concept back to the principles of ownership and notice established throughout prior modules. When a deed is recorded in the county recorder's office, it becomes part of the public record, creating constructive notice that ownership of the property has changed. This means that all parties, including lenders, creditors, and potential buyers, are presumed to know who holds title to the property. Recording a deed therefore safeguards the grantee's ownership rights and prevents others from making conflicting claims. Under ARS Paragraph 33-411A, every deed or conveyance of real property must be recorded in the office of the county recorder where the property is located to be valid against third parties. If a deed is not recorded, it remains binding between the grantor and grantee, but provides no protection against subsequent purchasers or creditors who may later acquire or record an interest in the property. The legal effect of recording a deed. Recording a deed establishes priority and public notice. Arizona follows the race notice rule, which means that a subsequent purchaser who records their deed first will have superior title as long as they purchase the property in good faith for valuable consideration and without notice of a prior unrecorded conveyance. This system incentivizes prompt recording and ensures that ownership disputes are resolved through a clear order of recording rather than verbal or private claims. For example, imagine that Maria sells her Tucson home to Robert and gives him a signed and notarized deed, but Robert forgets to record it. Later, Maria fraudulently sells the same property to Anna, who has no knowledge of the first sale and promptly records her deed. Under Arizona's race notice statute, Anna would hold legal title, and Robert's unrecorded deed would be subordinate because he failed to record it. Constructive notice versus actual notice. The concept of notice is central to understanding the implications of recording. There are two primary types. Actual notice, when a party is directly informed of a prior interest, such as being told that the property has already been sold or seeing a copy of an unrecorded deed. Constructive notice, when a document is properly recorded, the law presumes that everyone has knowledge of it, even if they haven't personally seen it. Recording creates constructive notice, protecting the grantee against subsequent claims. Without recording, only actual notice may protect the grantee, which is much harder to prove in a dispute. Consequences of not recording a deed. Failure to record a deed can lead to several serious consequences. First, it exposes the grantee to the risk of losing ownership priority if another buyer, creditor, or lien holder records an interest later. Second, it may cause title defects, complicating future sales or financing. Title companies require a clear chain of title before issuing insurance, and an unrecorded deed can create a gap in ownership history that must be resolved. For instance, if a buyer receives a deed but fails to record it, and the seller later incurs debts or judgments, those judgments may attach to the property. Because the public record still shows the seller as owner, creditors can place liens on the property, and the buyer may face legal challenges to clear title. Additionally, unrecorded deeds complicate probate and estate matters. If the grantee dies before recording the deed, proving ownership can become difficult or even impossible, leading to disputes among heirs or challenges from third parties. Practical example, consider James, who buys a parcel of land in Pinal County, but delays recording his deed for several months. During that time, the seller, still listed as the record owner, uses the property as collateral for a loan. When the seller defaults, the lender forecloses on the property, unaware that James had already purchased it. Because James never recorded his deed, the lender's lien takes precedence, and James loses his ownership rights. This example demonstrates how failing to record can result in devastating financial loss. Case example: Main Island Partnership, BIV Venture Capital Construction and Development Corp., 2001. In this case, the Arizona Court of Appeals confirmed that recording a deed provides constructive notice to all parties and protects ownership against subsequent purchasers. The court held that an unrecorded deed is valid between the parties, but not against later good faith purchasers who record first. The ruling reinforced the principle that prompt recording is essential to preserving property rights under Arizona's race notice statute. How recording occurs. Recording a deed in Arizona is a straightforward process. Once the deed is signed, notarized, and delivered, it is submitted to the county recorder's office in the county where the property is located. The recorder indexes the deed by grantor and grantee names and assigns a document number. The original deed is then returned to the grantee after recording, while an official copy remains part of the permanent public record. Recording fees vary by county, but the cost is minimal compared to the protection it provides. Most title and escrow companies handle recording as part of the closing process to ensure there is no delay between the transaction and the public record update. Discussion: Why is recording a deed important in Arizona real estate transactions? Answer: Because it provides constructive notice to the public, establishes ownership priority, and protects the grantee's title against subsequent purchasers or creditors. What could happen if a grantee fails to record their deed? Answer: They could lose ownership rights to a subsequent good faith purchaser who records first or face complications with title insurance and future transactions. What type of notice is created when a deed is properly recorded in the county recorder's office? Answer: Constructive notice, meaning that all parties are presumed to know about the recorded ownership. Review summary: Recording a deed in Arizona serves as a critical safeguard in real estate ownership. While an unrecorded deed remains valid between the grantor and grantee, it provides no protection against third parties under the race notice system established by ARS, paragraph 33-411. Recording creates constructive notice, establishing ownership priority and protecting the grantee's rights from later claims, liens, or fraudulent sales. Failing to record can result in severe consequences, including loss of ownership priority, title defects, and exposure to creditor liens. Arizona case law, including Main Island Partnership, Venture Capital Construction, reinforces that prompt recording is not merely procedural. It is essential to preserving legal ownership and ensuring marketable title.